Good morning, everybody. Good afternoon to who is joining from China. My name is Alessio Pettino. I'm the knowledge coordinator of the USME Center in Beijing. It's a great pleasure to welcome you today to join this webinar on commercial dispute resolution in China. It's a very, very important topic at the USME Center. Every week we receive emails, inquiries from SMEs on how to deal with commercial disputes. Unfortunately, in some of these cases, these disputes even involve scams or very unfortunate situations. We see from these inquiries that there is still a lot of confusion, a lot of uncertainties on how to deal with this. How does arbitration work? How can I, is it enough to go to the police in Europe or like things like this? So that's why we decided to organize a webinar on this topic today. And I would like to say that very important part of this webinar is also going to be on the prevention on commercial disputes, because of course we have to know how to deal with disputes, but it's even more important to know how to prevent such disputes. There will be a few case studies at the end, a couple of case studies, and as well as a Q&A session. Even though the Q&A session is at the end, we invite, of course, everybody to submit questions in the Q&A box that you see on the bottom of the Zoom at any time, because we will prioritize the questions asked first. So before beginning the presentation, I would like to spend a few minutes on the USME Center. For those of you who don't know us, the USME Center is a project funded by the European Union since 2010. So 12 years already, and our mission is to help European small and medium enterprises to get ready to do business with China or in China, to get more familiar with China, to help them export to China, and so on. We are in a third phase, and which is implemented by a consortium of chambers of commerce and business organizations operating in China, which you can find here at the bottom. And I would like to say that among these, the Italian Chamber of Commerce is the leading partner, and it's also the co-organizer of this webinar today. This webinar was made possible thanks to their strong support. We partner up with many agencies, organizations, both from government, businesses, and we have a physical office here in Beijing, which is where I am now. We also have colleagues based in Brussels, so it's reaching out to us is very convenient. Very briefly, we provide four main types of services. The first one is what we call knowledge center. Basically, we write reports, case studies, guidelines on different vertical industries, as well as cross-cutting issues. And this is a screenshot from our website. You can access all these publications free of charge from our website, but you have to be logged in on our website. Second service is an advice center, which is a sort of help desk that we have that European companies can use to ask us basically any questions they have, including technical questions, including legal questions. It's a first level kind of assistance, but we have some experts that will be happy to help you free of charge. There is we also have database of FAQs, including something very interesting, which is we call it self-diagnosis tool. Basically, the sort of quiz free that that you can do. Basically, there are different questions and different answers, and based on the answers that you select, at the end you will receive a score with an assessment of your answers, basically saying which aspects were correct, which aspects were wrong, or not the best options, and then you will receive a list of relevant FAQs, relevant reports, relevant webinar recordings that we have. So it's very funny and also very useful, and I invite you to try it out. Third service we have is a training center. Basically what we're doing today, we invite experts from different fields to train, to present on different aspects of doing business in China. And by the way, we record all the trainings we do and upload the registrations on our YouTube channel. This is a screenshot from our YouTube channel. You can rewatch all the recordings there, including today's webinar. It will be recorded. It is being recorded and it will be uploaded on our YouTube in a few days. Last, we have an advocacy platform, basically sort of working group through which we try to disseminate information about new regulations or drafts for comments, and or we organize policy meetings on new policies and so on. We are going to do, we have a lot of events in the pipeline. I mentioned we are at the end of the current phase. So there are still a lot of some activities to deliver, and you can see here a screenshot about a few upcoming ones, including a final conference on the 10th of January. There will be representatives from the EU institutions, and we will share some of the achievements that some of the main achievements that we achieved during this phase, and we will anticipate what is coming after with the new phase of the project. So that's it about us. So now I would like to, it's my pleasure to introduce the two experts we have today. I'm very, very happy that we invited and the two experts, very, very renowned experts from a very renowned firm agreed to join this webinar today. First expert is Yuan Su Yu, who is a partner at Hogan Lovells Fidelity, based in Shanghai. He's a very seasoned lawyer with a lot of experience and proven track records in litigation and dispute resolutions, both commercial dispute, but also IPs. He has assisted many clients, many international clients on different cases involving Chinese partners. Second speaker, also from Hogan Lovells Fidelity, is Miss Helen Yao, who is an associate. Also, she is very experienced in commercial disputes, in IP, especially litigation and arbitration, but also IP. And she also worked in other Chinese law firms. So it's a pleasure to have you here, Su Yu and Helen. Thank you again on behalf of the USME Center for joining today and sharing with us your experience, insights, and what European companies, in particular small and medium companies, should pay attention to. So I'll give the floor to you now. Thank you again.
Thanks, Alicia, for showing this. We will show our slides. Wait a minute. Okay, play. Okay.
Okay. Good morning, everyone. This is Su Yuan from Hogan Lovells Fidelity, and my colleague Eni Yao will join this call with me together to introduce some ABC about commercial disputes resolution in China. Next page. Next. Hogan Lovells Fidelity will spend 1 minute to introduce our firm, Hogan Lovells Fidelity. Hogan Lovells Fidelity is an association firm set up by an international law firm, Hogan Lovells, and an local law firm, Fujian Fidelity law firm, in 2016. So this platform, we can directly provide legal service for foreign companies. You know, in China, the foreign law firm and foreign lawyers is not permitted to practice Chinese law. Of course, attend Chinese court hearings, but we can do this. This is our law firm. Next page. In this webinar, we want to talk about 5 points. One is we want to give you an overview of foreign-related disputes in China. The second is how to deal with commercial disputes in China, litigation, arbitration. The third is how to prevent disputes in doing business with your Chinese partners. We want to give you some tips. The fourth is 2 cases that we want to discuss. And the fifth is some tips for dealing with commercial disputes when it really arises. The last part is Q&A. I will talk about 1, 3, and 5, and my colleague Elaine will talk about 2 and 4. Next page. Okay, before starting, I have a question to our audiences. We know that China is a big country, so there are a great number of disputes every year. So I want to do is there anyone know how many cases will be handled by China courts per year? This is not an easy question, maybe. Okay, I will provide the answer. According to this chart just showed on the screen, you can see that in last year, 2021, there is almost more than close to 35 million cases were accepted by China courts, and about 30 million cases were closed by China courts. This is a huge number. I want to give you another number. There's only about 140,000 judges in China. This means that one judge will have to handle more than 200 cases 1 year. So you can see that the workload for the judge is very heavy. Next page. Next. Above 上页. Okay, we can see that among this number of cases, we can see that the cases related to foreign related litigants has increased rapidly in past few years. In 2018, that's just about 15,000 cases, and in 2021, there's more than 20,000 cases. Next. This year, Hangzhou Intermediate Court issued a white paper. It provides more details on foreign-related civil cases. We can see from this figure 1, you can see that in the past 10 years, the number of cases goes rapidly. In 2012, that's just only about 217 cases. And in last year, it's about 560 cases. Next. Okay, we can see from figure 2, about 1/3 cases are related to Europe. This means that either the plaintiff or defendant are from the Europe, and another 1/3 is from the USA. Next page. This is the figure 3 is about the dispute amount. You can see that the disputed amount in total in 2020 is more than 26 billion RMB. It's a huge number. Next page. We can see from figure 4, you can see that it provides some types of cases handled by the courts. The first largest dispute is about borrowing dispute, and the second largest dispute is about sales contract disputes. So from this part, we want to give you an impression, a general information on disputes in China. You can find that 1, there are a lot of disputes before China courts. This means that the judge is very busy. So we should prepare the case very carefully before filing it with the court, because the judge is very busy. And we should be more patient to wait for the judge decision, because the proceeding period will be longer than you expect. The second, you can see that about 1/3 cases related to foreign companies are from the European. This is not strange, because European is the first or the second largest trading partner with China. Okay, next part, Amy will introduce some questions about some general rules about disputes in China and how to deal with disputes in China. Eileen, your hand.
Yes, thanks, Su Yu. In this section, I would like to introduce the two dispute resolution mechanism in China, that is arbitration and litigation. So first, I will give you a glance of the general rule on civil litigation in China. Like the Chinese court structures like that. In China, there are 4 levels of courts. The highest level is the Supreme People's Court. And the second one is the High People's Court in each province. The third one is the Intermediate People's Court in each city. And the lowest one is the District People's Courts. In addition, China has also courts with specific functions, such as the Railway Transportation Courts, Maritime Courts, IP courts, and financial courts at the Intermediate People's Court level. Generally, if you would like to file a lawsuit with the court, it will go to the District People's Court and appealed to the Intermediate People's Court. And sometimes, in some circumstances, the Intermediate People's Court and the High People's Court will have trialed some first instance cases in respect of certain types of disputes. For example, when the amount of damage alleged in the disputes exceeds a certain threshold, like in China, like in Shanghai, if the amount exceeds RMB 100 million, then the Intermediate People's Court will take the case, or the case have significant political or science effects. And then there is general court proceedings, like how to initiate civil litigation. First of all, we should file a complaint with the court, and then the court will send a notice to the defendant and let him know that he got sued, and he should file a defense within the limited period. And there is evidence submission period for both parties to submit evidence. And the defendant can also file its own counterclaims, if any, before the end of the evidence submission period. And then if the defendant did not, and defendant can also initiate a challenge to the jurisdictions if the defendant consider that the case should not be heard by the current court, and the case should move to the like the place where the defendant is domiciled, something like that. And then after all the proceeding issues ends, the court will arrange oral hearings, 1 or 2 oral hearings for both parties. Then the judge will investigate some basic facts and provide opportunities for both parties to representing their arguments. And then the court will issue a judgment. And there is one court mediation proceedings before the issue of judgment. If no mediation, if the mediation is not successful, the judgment will be made promptly. General civil lawsuits must be completed within 6 months from the acceptance of the case. And then if the party, either party is not satisfied with the judgment, then appeal can be filed to the court at the next level about the court of the first instance. And then it comes to the enforcement of the judgment proceedings. Like if a party fails to voluntarily perform the judgment, the other party can apply to the court for enforcement. And the time limit is 2 years, starting from the last day of the time period for satisfying of judgment or the effective date of the judgment. And the applicant who would like to apply for enforcement of judgment should file an application to the court of the first instance or to the same level court where the property is located. And after that, after the enforcement court take the case, the judge would impose some compulsory measures against the non-performing party, like it will require the party to report its asset status, check the party's bank accounts, and freezing the bank accounts. And also selling the assets of non-performing party prohibits the party's legal representative from leaving China, and also record the non-performance in a credit ranking system and disclosure its information to the public. In judicial practice, we think those measures are quite effective, and in many cases, the defendant just willing to pay us back once they know that the judge will record its non-performance in the credit ranking systems. And then I would like to talk about some general rules on arbitration in China. In this slide, there are a list of Chinese arbitration institutions that are commonly used, like CICC, Shanghai International Arbitration Centers, and Shenzhen Court of International Arbitrations. Those institutions have been established for a long time, and the arbitrators there are sophisticated and professionals. So if you would like to go to choose an arbitration as a dispute resolution, it will be a good choice to choose the arbitration institution in the following list. And as I just said, that if you want to dispute to go through the arbitration, you should first thing first, you should have valid arbitration agreements. So for an arbitration agreement to be enforceable, it must express the parties' intention to arbitrate, set out the matters to be arbitrated, selected an arbitration commission, like the commonly used in China arbitration CICC, Shanghai International Constitution, and being writing and validly executed and be entered into by individuals with for the civil capacity or by legal persons. And last but not least, the subject matter submitted to arbitration must be arbitrable. Like sometimes if the disputes involve some government acts, it cannot be arbitrated. And then when it comes to the arbitrators, the arbitrational tribunal can be made up of 1 or 3 arbitrators. And if party agrees to set up a tribunal of 3, then each party will select it or authorize the chairman of the arbitration commission to appoint 1 arbitrators. And there is a general arbitration proceedings, like if you would like to commence arbitration proceedings, a party must submit to the arbitration institution as stipulated in the agreements, and file a written arbitration agreement and file a written application for arbitration. Then you should set up a tribunal, pick up the arbitrators. After that, the tribunal will arrange an oral hearings. And during the hearing, the evidence submitted by each party must be presented during the hearing, and the party has the right to examine the evidence. After that, the word will be made. And please note that the arbitration word is generally final and binding on the parties once it is rendered by the tribunal. So it is similar to the litigation enforcement of effect judgment. There we also have proceedings for enforcement of an arbitration awards. Like if you would like to enforce the awards, the applicant must apply to the intermediate people's court, where the respondent is domiciled, or where the respondent property is located to enforce it. And the time limit is also 2 years from the last day of the performance period specified in the arbitration awards. In that proceedings, if the respondent, the respondent can also ask a court to reject the enforcement of the arbitration awards on the following grounds, like there is no valid arbitration agreements between the party, the composition of the arbitration tribunal, or the arbitration proceeding is not in conduct, is not legal, and the subject matter of the dispute is not contemplated by the terms of arbitration agreements, or is not arbitrable, and then the arbitration, all the arbitration words is in conflict with public policy. This like a catch-all clause where the court generally use if there is no solid grounds to refuse enforcement of the arbitration words. Here comes the pros and cons of the two dispute resolution mechanisms. Like for the litigation, the advantage of the litigation is it costs less than arbitration, and either party can appeal if they are not satisfied with the first decision. And on the other side, if you choose the arbitration, it will cost more than litigation, and the awards is final and binding on the parties. In terms of the disadvantage of the litigation would take more time than arbitration. Like it is about 6 to 12 months or more for first instance proceeding only, and a similar timeline for the appeal. While on the other side, the arbitration only take much less time. It's like 6 to 9 months or less. And then in addition, the workload of the Chinese government is extremely heavy. So it's just like we said in the previous section. So it will cause them to lack the patience or energy to fully understand the parties' transactions. While in the arbitration proceedings, most arbitrators, there are some sophisticated lawyers or well-known law school professors. They will be more willing to understand the commercial transactions in depth, so as their workload are not as heavy as the judges. Yeah, so Su Yu would talk about the next section, that is about how to prevent disputes in doing business with Chinese partner. Su Yu, I will turn it over to you. Okay.
Yeah, thank you. Yes, this part is about how to prevent disputes in China with your business partners. To be honest, it's very difficult to prevent disputes. We know that everything has risk unless you do nothing. We can't prevent all risks, but we can try to minimize the risk. If you have an in-house lawyer or outside lawyer, they can help you draft and review the contract and provide legal opinion before starting business. So this will minimize the risk. However, we understand that this will need some money, and some small companies may not have such budget. In such situation, what can we do? I think there are still two ways to reduce or minimize the risk without large legal cost. First, know your partner well before starting business with a new business partner. We always say that the world is a global village, so you can get many information from the internet. You can even do some investigation by yourself. In China, every company's general information can be found from this government website. This is National Enterprise Credit Information Publicity System. You can find the company's official name, registered address, shareholders, capital, and other information. The most important, this is free. You should make good use of such information. For example, if you find your partner was recently registered, you may be more careful. Do not completely trust the introduction provided by your partner or from the partner's website. You should trust the information from this government website. For example, we also know that the capital of a company is very important in China because it usually represents the strength scale of the company. For example, you can see that this is a screenshot of a company. The registered capital is 80 million RMB. It's just about 10 million euro dollar. This is not a small company when you see this information. But in China, the registered capital is only a number promised by the shareholders to invest. It doesn't mean they really have invested such money. They can't decide the capital contribution timetable freely. So you may need to forward check the paid up capital. There are two ways. You can ask the partner to provide their recent business license, which has such information, or engage a local counsel to search similar information. The cost is not high. Next page. You can see from this screenshot, this is the same company of the last page. You can see that this paid off capital is 0, which means that this company may not have any asset. So you should be very careful when doing business with it. The second suggestion, next page. You should have a good template of contract. You can engage a counsel to provide a template based on your business model. The contract also should have some necessary terms. For example, we know that the product quality dispute is not rare in practice. Your change partner may provide one certificate of quality to you first. However, you may find that not all products meet the great quality standard after you receive the whole products. In such situation, neither side will agree with each other. There is dispute. Then select a third party to test the disputed product is very important, but it's very difficult to reach consensus on selection of the test institute. So we suggest you to appoint a test agency in the contract in advance to avoid such dispute in the future. Of course, our terms are also very important, such as the specified exact terms of payment and performance standards, include specified dispute resolution clause, pay careful attention to the details, such as pages of the contracts and signing properly. Of course, you should make sure the Chinese version of the contract is consistent with English version, blah, blah, blah. So these are two suggestions we can provide. If you don't want to, or don't have some legal cost on this. Next part, my colleague will introduce two cases about how to deal with disputes before China courts. Eileen, here you are.
Yeah, thanks, Suyu. In this section, we will give some case study here. We will talk about two typical cases that the foreign companies may encounter in doing business with Chinese partner. The first case is it involves contract disputes relating to defaults on refund of deposits. The case background is that all clients is a multinational healthcare insurance company, and the counterparty, the defendant, is a seller of ventilators, and the company is a newly established local trading company in Shanghai. And the plaintiff and the defendant entered into purchase agreements on ventilators in 2020. And those ventilators was aimed to be used in the hospitals that aim to cure COVID-19. And the defendant failed in preparing a request to ventilators for delivery, and had also shown no intention to refund deposits over RMB 23 million, which approximately equals to 3 million euro. And since there is no arbitration agreements in the sales contract, we represented a client to file a civil lawsuit against defendant with Shanghai Intermediate People's Court, claiming that the plaintiff or client has the right to unilateral terminate agreements, and requested defendant to not only pay back deposit and also undertake the liability for breach. Luckily, the court, the first instance court, ruled that the defendant ruled in favor of us and ruled that defendant should refund deposits and compensate our clients for its loss of interest over RMB 1 million, and also bear all the court fee for this lawsuits. As you can see, in Chinese civil lawsuits, the winner do not bear the court fee. And then the defendant was not satisfied with the decision and filed appeal. And the appellate court, after carefully reviewing our case, and affirmed the original judgment, and the judgment. And the first instant judgment has came into effect since then. And now we are going through the enforcement proceeding of the court decisions. Since the defendants did not pay back, haven't paid back the deposit, of course they won't. And we can only apply for the enforcement of the court decision with the enforcement department or the first instance court. And the key issues we would like to address here is that how to enforce the court decisions here. Like in our case, at an early stage, when our clients find that the defendant did not have the capacity to deliver the ventilators on time. They were very nervous since the amount is quite huge. So they filed a criminal complaint with the local police department. And then because it is related to COVID-19, so the government and the police office paid much attention to these issues, and they commenced the criminal investigations on this. But in the end, they found the issues only involves civil commercial disputes, so they withdraw the case. But the good thing of this is that the police office frees the bank accounts of defendants, in which there are almost all the money all clients paid in the bank account. And then our client engaged us to contact the local police and collect the information of the bank accounts of the opposing party. And then we initiate a civil litigation against this party. And in the meantime, we applied to the court for asset preservation order. With this order, the court will issue a notice for the defendant's bank assistance to freeze account. So luckily, our clients will be able to get all the money back. Next case, it is involved product quality disputes. The case background is like that a Korean trading company purchased stainless steel tubes from a Chinese manufacturer, and the company paid for the tubes and authorized the manufacturer to send them to Korea. And the company engaged the SGS, a multinational testing and inspection and certification company, to do the inspection on the tubes that arrived in Korea and find about all the tubes were the same steel tubes. which is not as stipulated in the sales contract, right? So, since there is no arbitration agreements in the sales agreement, in sales contract, so the dispute also goes to the litigation. The company filed a lawsuit against the manufacturer with the Chinese courts and claiming that the manufacturer's default on the delivery of goods as stipulated in the sales contract constitute a fundamental breach of contract, and therefore the manufacturer should return the deposit paid by company and compensated for its loss. And since the fact is very obviously, and the defendant do breach the contract by default, by sending the wrong products, so the court ruling that defendant should refund the deposit and pay the appraisal fee, the translation fee, or the certification fee, and also the court fee as well. So the key issue we would like to address here is the appraisal report on product qualities, because in this case, both two parties submitted appraisal reports. Like the plaintiff submits an appraisal report issued by the S3S based on inspection of the tubes that arrived in Croatia, which confirmed that the tubes were seamed steel tubes. And the defendant submits an appraisal report issued by the Tianjin Inspection the Quarantine Bureau. It is an official authority based on its inspection of tubes that to be exported, which confirmed that the tubes were seamless steel tubes. And the court opinion is that it should the CGS appraisal report, and the reason for the court to do that is that the goods in question was inspected by the Tianjin Bureau only to prove the goods exported by the manufacturer comply with the mandatory requirements of Chinese national technology specifications, and does not necessarily deduce that the goods meet the contractual agreements. So here is some tips, takeaway points for or notes for the goods or appraisal or testing. It is that in general, and as we understand that, a Chinese court generally may not recognize appraisal report resulting from the inspection conducted in a foreign country. And but in some certain precedents, the court do recognize the appraisal report issued by the testing agent that the party appointed in the sales agreement. So that is why, as Sui said in the previous section, that we should have a clear contractual terms, including the testing agency, appointment of the testing agency there. And the third point is that if no agreements on a testing agency, it will be more persuasive for the court to choose a multinational testing company, which has branches in China, like just the S3S in this case. And also, we would like to mention that if in some circumstances, we may also consider sending the sample products to testing agents in China for appraisal. Okay, so I think you will cover the next section, which is the tips for dealing with cross-border commercial disputes, right? I will turn it over to you.
Thanks, Eileen. Yes, we'll provide some tips for dealing with commercial disputes in China. We know that no one wants to say a dispute, of course, except lawyer. But in practice, we may have to face some disputes sometimes. If a dispute really arises, how to handle it? We list some tips for your reference. The first, collect evidence in time. When a dispute arises, you usually inform your partner and raise some request, ask them to resolve the problem. Please try to do this by email rather than call. This is because the email can be easily used as evidence later. Another issue is that, in the early stage, your partner may want to admit the problem because they want to continue doing business with your company in the future. So this may be a chance for the parties to negotiate the resolution way. However, if a dispute cannot be resolved by friendly negotiation, you may consider to take legal action. In this step, we suggest you to first consider to engage a local lawyer to send a demand letter before filing the case with court. This is because that sending a demand letter is an efficient and cost-effective method. Moreover, some Chinese companies are also not familiar with foreign-related litigation and arbitration procedure, so they may pay more attention to such demand letter, especially the letter is from lawyer. So they may compromise. This will save your cost and time. If the letter doesn't work, you may have to consider whether to file litigation or arbitration. In this stage, we have two such suggestions. First, please prepare formality documents earlier. In China, if you want to submit a case to the court or arbitration, you should submit some formality documents, includes power of attorney, certificate of incorporation. Under Chinese law, such formality documents should be first notarized by a local public notary and legalized by Chinese emperor and consulate, which may take more than 3 months based on our experience. The second, if you have a strong case and know some asset close of the opposition party, we suggest you to do APO, which means asset preservation order. You can try to file such application with court. As Ellen just said, it's not difficult to get such order, in the court if you can provide guarantee. If your application was approved by the court and the court successfully preserved the defendant's asset, such as bank account, you will not have any concern on the petitioner enforcement risk in the future after you obtain a favorable court decision or arbitration award. Moreover, the defendant may tend to settle with you if they don't have strong defense argument and their asset has been preserved by the court. It will also save you the cost and time. Then you can get the refund in short time. The last tip is about criminal complaint. To be honest, we usually don't suggest clients to do so unless you have strong evidence to prove that there is a crime. This is because that the threshold for police to accept the case is very high. So we don't want you spend money on this. Okay, thank you. This is what we talk about today. I think the last part is about the question and answer.
Yes, indeed. Yes, indeed. So you, Ellen, thank you very much. Maybe before we have received a few questions already, but before moving to that, I would like to make one final comment on the second case study that Ellen introduced, which is something we see very, very often here at the USME Center. So basically companies buying from China, but receiving goods with a lower quality. Actually, what can be done in many cases is to have an inspection of the goods before they leave China. So when the goods exit the factory, or even are loaded on the ship, you can hire an inspector, like a consultant, to inspect the goods and conduct some testing. Actually, this is very effective and it's not very costly, and it's really could potentially save a lot of trouble. So we always suggest this option. So we have received a few questions, but of course, if there are other questions, I would invite the participants to write them in the Q&A session, in the Q&A section. The first question, so you, Hélène, would be, it's actually a very, I think, basic question. So for sales contracts, just normal sales contract involving goods, normal goods, is it notarization needed in China? We see that there are some European companies selling to China, and then the Chinese importer say that the sales contract needs to be notarized, and they ask the European company to pay for notary fees. Is this required?
Yes, thanks, Alessio. As we know, there is no mandatory requirement for those contracts to be notarized. But if both parties that they agree on this, that it should be notarized with the local notary office.
Okay, but maybe could it be related to the fact that the Chinese company will need to convert currency from renminbi to foreign currency, and the bank requires, let's say, the notarized document, sales contract as a supporting document, as far as you know?
Oh, it's so, as I said, it is not mandatory by the law, but
Okay.
if the bank account ask for that, if the bank ask for that, it should be done in that way.
Right. Very good. All right. Thank you. We have another question, which is how to deal with. So there is an agreement which stipulated arbitration and choose an arbitration center in Europe. Not an arbitration institution in China, and this was agreed in the sales contract. So the arbitration institution finalized the award in favor of the European company, but now the Chinese company refuses to enforce it. What should the European company do?
Yes, thanks, Alessio, for asking this. It is quite
I think you have
common
discussed this
situation.
in part 2.
Yeah.
Okay, even if it's a foreign arbitration institution and not a Chinese one.
Yes, we can enforce a foreign arbitration awards in China, but there is some proceedings that the applicant should initiate. Like the first step is you should apply for the recognition and enforcement of the word before a competent Chinese court. Usually they are the intermediate people's court. And in practice, some foreign related civil case division of those courts will be responsible to review those applications. And in the case that the court decides to recognize the foreign arbitration words, the application then will have to further apply for the enforcement of such foreign awards before the enforcement division of the same court, like the enforcement proceeding in the general civil lawsuits. We have dealt with such requests from our foreign clients before, and many of clients have obtained their money, successfully get their money back. So if our audience have that request, we are glad that we can provide some legal advice on this matter.
Very good. There is an interesting question in the chat. I will read it for you. A frequent situation bringing to litigation between companies registered in China is the lack of payment for delivered goods. The debtor may not pay, but promise to pay later. And actually, we've seen in another case that they are using lockdown reasons. They say we cannot go to the bank because lockdown measures, but in practice, we are not aware of such lockdown measures. So and so the debtor pushed the case until it finally becomes clear that the debtor will never actually pay. So what is the time limit in such cases for filing a lawsuit? It's in the chat.
Hi, sorry. My connection is not quite stable here.
Okay.
Let
So
me share.
I don't know if you got the question, or maybe if Suyu wants to answer it.
Yeah, I just say the question, free constituent different litigation between terms in China is lack of payment availability. They may not pay, but permit to pay it, and therefore push the case until it finally becomes clear that labor never actually pay. What's the time limit for filing lawsuit? Oh, in China, the general time limit is 3 years. 3 years.
Okay.
So I think you have enough time to prepare the case. As we just discussed in the webinar, that if you want to file a case in China for a foreign client, you should prepare the POA, some phonetic documents, especially POA, power of attorney. And the power of attorney should be notarized and legalized first.
Which takes up to 3 months, we saw in the presentation. So better to start doing it as soon as possible.
Yes.
Thank you. Another question in the Q&A box. Are civil procedures possible in online, especially during these pandemic times? So is it possible for a company outside China to sue a company in China using such online procedure? If not, how it can be done?
This is a good question and very interesting. Just as I said, there are 2 procedures. If you want to file a case with the court, you should prepare and submit some formality documents. Such formality documents must be notarized and legalized. This is the case under Chinese law. If you have filed the case with the court and the court has formally accepted this case, the upcoming court hearing can be held online. So in summary, you can't file the case online through outside of China, but you can attend the hearing online in later stage.
Okay. So what if in many cities now there are these lockdown measures and things like that, which makes it impossible actually to do many things, to initiate many proceedings, or what can you do in such cases?
Yes, just like me and Elaine, we are still under lockdown in Shanghai. It's more than 2 months. So to be honest, this is arguable in China for the lockdown. There are many comments on this. So this really brings some difficulties for us to handle cases. For Kent, I think that what you can do is to collect evidence during this period, such as the government notice, certificate from the government to prove that you are under lockdown and you can't perform your obligations under the contract. This may be a good argument in the future.
Okay, that's clear. And maybe one last question that we still received a few days ago. So there is a dispute. Let's say you are selling a product to a Chinese importer, and then the contract and everything was signed, even notarized. What if the buyer, the Chinese importer, refuses, let's say, to pay for several reasons? What would be the first step that you as a European company would need to do?
Can you repeat it again?
Yeah, if there is a commercial dispute, instead of what would be the first step to do? Maybe just file a lawsuit directly, or maybe I don't know. Of course, if it cannot be solved by friendly negotiations, what would be the first thing that a European company in Europe would need to do?
Okay, that I introduced earlier, we suggest the first step is to collect evidence. in the early stage, because in the early stage, the Chinese company may admit their fault. So you should try to negotiate with your Chinese partner by email. This is also to collect evidence. If you can't resolve the dispute with your Chinese partner through negotiation, the next step, we also don't suggest you to directly file litigation because it will spend many money. We suggest you to engage a local counsel to send a demand letter, a lawyer letter. This may save the cost if it works. Unless it doesn't work again, so you may have to file litigation in China.
Okay. Okay, that's clear enough. So I think we are about we reached the end of the presentation. Or again, maybe I'll share another slide from my end. So thank you, Suyu and Ellen for this, for sharing your insights. Of course, for the participants, if there are other questions, please feel free to send them to us by email. We will be happy to try to look into these questions and recommend them to the speakers today. So just a few final words. We are going to share the recording of this webinar on YouTube, as I mentioned. And here on this slide, you see a QR code. It's basically a short survey, a feedback questionnaire that we would really appreciate if you could fill. It takes 1 or 2 minutes. It's basically, it also gives, it's also a way for us to know if the topic was interesting, if there is another follow-up event webinar that we can do on this topic or on a more specific topic. So we would really appreciate if you could take the time to do this. So I think this would end our webinar today. Thanks again to the speakers, Yuan Suyu and Ellen Yao from Hogan Lovells Fidelity, and thanks to all the participants for joining us, and see you next time.
Thank you.